So please, ladies and gentlemen, thank you for a big round of applause. We're now in a situation with the 3 estates of the Constitution where things are going wrong in the secret courts and in ordinary courts that turn into secrecy. Things go wrong, such as poisoned water and things like that. And if you don't talk about it in Hansard, obviously once it's in Hansard, people can talk about what's in Hansard, then people aren't allowed to know about what's going on. Now, I have encountered 2 big problem areas in terms of secrecy in the judicial system. One is banning people from talking to MPs. That's the sort of hyper-injunction, as I put it in here, that in theory, for somebody to say to their MP, I was in case 773, and nothing else, would result them in being jailed. Right? Nothing about the case, just the existence of a case and talking to an MP would result in them being jailed. I take the view, and I'm not going to talk at great length. It's better to answer questions because that way you get a more interesting conversation. But if you want to read, I did about an hour's speech, and you don't want me to do an hour's speech last Thursday, and it's in Hansard, which you can get on the net, all protected by parliamentary privilege on the net. You can get it. I've got 3 copies here. I bought 3 because people might like to pick up a copy. It's quite an interesting particular debate. Right in the middle, you have these numbers for page numbers, column numbers actually, and then after it there are letters in WH's Westminster Hall, so you'll find that in here. So one issue I'm worried about is people being banned from talking to MPs. Within this debate, we looked at the Bill of Rights. The Bill of Rights is really the basic constitutional law of the UK. And Article 13 talks about Parliament having 2 functions. One is for the redress of all grievances, and the other one's for setting the laws. And it's important that people don't forget redressing grievances. But if Parliament doesn't know what's going on, it can't redress grievances. So the idea that things are so secret, like poisoned water, or potentially poisoned water on ships, that somebody is banned from telling an MP, in my view, is a fundamental, it's a constitutional disgrace. I don't think there's any question about that whatsoever. I believe Parliament can take action to deal with that. It's what's called a contempt of Parliament. In the same way as you have a contempt of court, you can have a contempt of Parliament. And in the past, various things have happened. In Big Ben's Tower, St Stephen's Tower, there were a couple of rooms sort of part of the way up which were used for imprisoning people for contempt of Parliament. Haven't been used for about 100 years. There's enough space for a few judges there, I think. So, there's one particular judge in Birmingham who, on 2 cases, has banned people from talking to me. In one case, they were threatened that their child would be taken into care if they talked to me, and the other one was threatened with jail. Right? And I think that's fundamentally wrong. So that's one area that I'm pushing for pressure on. And I think we need to make it very clear, as a country and as Parliament, that we will not stand for a situation where people are not allowed to talk about their problems to their Member of Parliament. We'll not stand for it, won't accept it. And the second one I want to look at is secret prisoners. And when I talk about secret prisoners, I mean people whose liberty is constrained and we don't know why. Some of those have gone through the criminal courts. One who is named in here is Martin McCabe, and because he's named in here, I can talk about him here, as well as talk about him in Parliament. He was somebody who drove his pregnant wife to Dover with her son, who was his stepson, and she was pregnant, and her son had basically escaped from foster care because he wasn't happy in foster care, is now living on the continent with her and the daughter that otherwise would have been forcibly adopted from her for completely spurious reasons. Right? Because there's a lot of people who leave this country because they're chased around by random decisions by the family courts. And one of the procedural problems that's developed in the family courts is a very simple one, which is this. The family courts make decisions based on expert evidence, but you're only allowed one expert. It's the expert the local authority wants, and you can't appeal for a second opinion. So I had a case in Birmingham where a mother her son has been adopted because she fed him on demand rather than according to a routine, and she wasn't allowed a second opinion as to whether she was a good parent on the basis of that decision. So this is a really dreadful system. I had another email from another family that had gone to Ireland last week. So this is a continual process going on. And the systemic problem comes from the reliability, the unreliability of expert evidence. So whereas if you go to a doctor and the doctor says you've got a disease or something else like that, you could go for a second opinion as to what the disease is. If you're in the family courts, you can't. You have no legal right to a second opinion. And that all happens in secret, which is why a lot of people don't know what's going on. And to be fair, a lot of the time it happens with poorer people who haven't got access to resources, so they don't know what's going on. I don't know if people know, but the Magna Carta that is in force in statute is actually the 1297 Magna Carta, not 1215 Magna Carta. And one part of that, there's only actually 3 clauses still in existence, and the details are in here. One of them is clause 29, which basically says equality before the law, that we shouldn't sell justice. Sadly, in this country, we do sell justice. If you've got a lot of money, you get a different answer to one if you haven't got a lot of money. And there are lots of examples of that. So, one type of secret prisoner are people who commit criminal offences, like going for foster care, and because there's a family court case associated, they can't be named. Other people who upset the judges, contempt of court, in a family court, and are imprisoned in secret. So there was one fellow down Poolway who was jailed, I think, for 14 months. He was in his 60s or 70s, and that was because he'd spoken to his step-grandson, when his step-grandson had turned up on the doorstep. Other ones, Yvonne Goder's mentioned in here. She's protesting about what's happened to some houses that her family used to own and no longer do for strange reasons that are detailed in here. So contempt of court is another issue, and I think it's very dangerous to imprison people without any public scrutiny as to what happens, because if you look at the accountability of the judicial process, the primary accountability, you can't have Parliament just sorting out the judges every 5 seconds. The primary accountability of the judicial process, and there's actually a reasonably good speech by Lord Neuberger recently, who's the Master of the Rolls, looking at the super injunction issue. Primary accountability is through people knowing what's going on. Right? Judgments, explanations, public justice. Well, we have a third section of our judicial processes, family division, which is mainly in secret. People don't know what's going on. They don't know the bases upon which decisions are taken. There is therefore no accountability. Accountability, in a sense, is explanation. And a third area is to do with mental capacity. And I dealt with somebody, I actually had an email from earlier today, Lee Gilliland's case. It's an interesting case to do with mental capacity because it's in the probate division, so it's not got secrecy. It's the same process as they use with the secret courts, where his GP, who hadn't seen him for 5 months, said, this bloke's a bit paranoid, right? And so he hasn't got the capacity to instruct a solicitor, right? And therefore, well, this is just standard stuff. Hasn't got the capacity to instruct a solicitor, so we need what's called a litigation friend, somebody who acts on his behalf. And the official solicitor, who is supposed to be the litigation friend of last resort, but tends to be first resort, comes in, official solicitor's name, Alistair Piclardo, has lots of staff who travel around the country in various courts. He comes in, and they agree that he's living in this house worth about £100,000. Bit of a row between him and his mother, given the death of his grandmother. They agree that, well, he should have half the money, 50 grand, and of that 37 grand should go to his solicitor. Now the question you have to ask, now the interesting thing about this one, this is all public, this is not secret at all. What was sad, well, the first thing is this, is he clearly does understand what the case is about. So there was a case some time ago, Maston and Lister versus Brutton and Company, which looked at the question of when somebody has capacity and when somebody doesn't have capacity. And the idea is you don't need extra knowledge to have the capacity to instruct a solicitor, you just need to know what the case is about. And we had Rachel Pullen's case where she was deemed to be too stupid to instruct a solicitor, so the official solicitor came in and had her child adopted. Right? Now that case, and you may not like the European Court of Human Rights, but that is now in the European Court of Human Rights. I do have a psychologist's opinion on her case, which shows clearly she's got capacity. She managed to present her case to the Court of Appeal down at the RCJ, Royal Courts of Justice, and they still said, well, go away, that's it. That's it, you've got no options here. And they just slagged me off for pointing out that some of the documents look rather dubious.